Good afternoon, everyone. My name is Charles Raether. I'm the managing partner here at AmLaw Group to discuss today a little bit more detail about what is currently being considered, what's not being considered, and how this could affect you if you already have an H-1B or you're considering to get one. So the first thing to keep in mind is this change affects only those who are applying or will be applying in the future after September, I believe it was 21st, 2025, for an H-1B. Now, here's a legalistic approach, and I think this is another example of where the Trump administration shoots first and then asks who's going, without thinking through everything. Because as it was written and how the executive order was drafted, it was drafted under the powers granted to the president to place limitations on people entering the U.S. I think it's statute or section 212F. And this was the same statute that President Trump tried to use in the past when he tried to put those visa bans on individuals from certain countries. So his power to limit people entering the country is not disputed. But the issue is, if you're already in the U.S., theoretically under this article of the statutes, he has no power to limit or make these changes. So that's the first question, that if they want to impose this $100,000, let's call it a tax, that can only extend to people that are outside the U.S. So that's the first thing to keep in mind. Again, as we've seen, President Trump tends not to burden himself with technical legalities and burden himself with the letter of the law. He just tends to kind of do what he thinks he wants to do. But I think if any of this gets to court, and I'm almost certain it will, these issues will come up and will make it very difficult for this $100,000 tax to stay in place. But let's kind of work through it bit by bit, and let's work through what the executive order says as of right now. So the first thing of what the order says on its face is that it won't affect them when they will go to extend that H-1B. So if you've already got an H-1B, I think you're safe. Nothing to worry about. And if you're still eligible for an extension, I don't think there should be any problems with that. Let's say you do not have an H-1B and you're looking at applying in the future. Yes, as of how things stand right now, you would have to, you or your employer would have to pay that extra $100,000. Now again, the constitutionality of this is very questionable. Why? Because under the law, USCIS is allowed to charge fees only that are commensurate with the amount of work that's done to make a review of the petition. So basically meaning the amount that USCIS charges has to be related in some sense to the amount of work that's required of USCIS to review a case and make a decision. Some people might say government employees are overpaid, but I don't think there's any government employee whose salary would be justified for charging $100,000 to review an H-1B case. So on those grounds, I think this new fee he wants to charge is unfounded. There's just no reason for supporting, any court could support that it would really take $100,000 worth of time from USCIS employees to review a case. If it's not a fee that's being imposed, what is it? Then maybe it's a tax. But as we all know, and President Trump has had some court cases on this as well, only Congress can raise taxes, right? The president can't unilaterally impose a tax of any sort. So again, this whole issue about the $100,000 fee or tax or whatever you want to call it really is unresolved. And I think stand up in court. Now, the big question, though, for you or anybody out there who's considering applying for the H-1B in the future, the big question is, okay, fine, this is not going to stand up in court. But to go to court, you have to have a plaintiff, meaning there has to be somebody who suffered some damage or harm from this. And that's going to take time, right? It's going to be an individual who ostensibly was harmed by this $100,000 fee. And it's going to take time to get through the courts and go through it, and it's never fast. So the question is, what's going to happen when lottery season in 2026 comes around? Will there be a court decision by that time? Will there be changes? And to be honest, no one knows the answer to that question. I guess it's theoretically possible a lower court might make a decision before the lottery and they might throw out this $100,000 charge. I'm sure in that case, the Trump administration would try to appeal that, but whether they would suspend the imposition of this charge or not pending the court case, that's just going to depend on each judge. So what I would say is, has the potential for grinding the H-1B program to a halt, at least in the immediate future, until it's resolved and how it's going to be imposed and whether it's even constitutional. Until that time, yes, it is in effect. Questions remaining as to how it gets paid, when it gets paid, and stuff like that. Because these things usually are done over the course of months, if not years. It's not just like overnight somebody makes a decision. I mean, it's a bureaucracy. You have to decide, okay, who's going to collect the fee? Who is it payable to? All these other things. And I don't think these issues were all worked out. If you heard about H-1B and you don't have the ability to pay the $100,000, or you currently have an H-1B and you're concerned about the program going forward, and you're looking for some other options maybe to allow you to stay here long term and acquire a green card, please feel free to reach out to us so that we can help you and put forward together a strategy that would help make your dreams become a reality.